McConnell as well referred to 20271 as a roadmap.
Correct.
And he commented as well that the new rule would establish, quote, an expeditious and uniform procedure for authorizing recognition of a judgment rendered by a federally recognized trial court.
That's correct.
He also went on to refer to 20271 as a procedural rule not designed to change in any way the substantive requirements for recognition or non-recognition of a trial court judgment, correct?
Correct.
He stated that tribal money judgments may receive recognition pursuant to Article 53 of CPLR, which is derived from the Uniform Foreign Money Judgments Recognition Act. You agree with me on that?
Yes, Your Honor.
So it's merely designed to provide, again, that roadmap for parties and courts how to seek recognition of that judgment. Right. So it goes in, initially it says that you need to file, and which you did, a notice of petition,
Yes.
a petition,
Yes.
and attach a copy of the judgment.
Yes, Your Honor.
Correct. Okay. But it also goes on to say, if, I think the word if may incline some sort of discretion in the court. So if the Supreme Court finds that the judgment, decree, or order is entitled to recognition under the principles of common law of comedy, it shall direct that the tribal judgment as a judgment of the Supreme Court, thereby enforceable in New York State.
Correct.
And that's what you're looking to do, correct?
Yes, Your Honor.
I don't think
Exactly.
anyone's going to dispute you. You're looking to do that.
I don't think there's any dispute, Your Honor.
So that mechanism is to merely file those three documents.
Correct.
Okay. Now, mere compliance, would you agree, with the procedural requirements does not automatically entitle recognition of the tribal judgment? Would you agree with that?
I would say yes, Your Honor. There is a certain element of discretion.
Right.
But I would suggest to the court that if we came to court with a judgment written in crayon on construction paper and it said it was a judgment of the Court of Mars, that would be an aberration. But in this case, the Cayuga Nation is a well-known entity in Seneca County.
I think as far as what you're saying right now, they did formulate a court. They did pass a judiciary law.
Yes.
They passed a business ordinance for regulations where the foundation of this case involves a situation where in this instance, Mr. Seneca Carlin apparently did not have the license which required under the business ordinance regulation.
That's correct, Your Honor.
Okay. So if you look again at 20271, it refers to comedy.
Correct.
All right. And comedy is a voluntary decision by one state to defer to the policy of another, especially in face of a strong assertion of interest by the other jurisdiction. So it's within the sound discretion of the Supreme Court to grant recognition. And that's from the Unkachung Indian Nation case versus Treadwell. You're familiar with that?
Yes, Your Honor.
Okay. So that case, again, referred to would support your situation, that a tribal judgment is a foreign judgment. So the principle which determines whether we give effect to foreign legislation is that of public policy. And where there's a conflict between our public policy and the application of comedy, our New York State own sense of justice and equity is embodied in our public policy and will prevail. And that was the Lippens case out of this court back in 2016. Is that right? All right, so I think we're in agreement that Article 53 applies, as Mr. McConnell indicated.
But we contend, Your Honor, that Article 53 does not apply in this case.
Well, didn't you agree with me when I said, when Mr. McConnell stated that tribal money judgments may receive recognition pursuant to Article 53 of the CPLR?
Yes, I'm sorry. However, 202.71 is very specific.
It's very specific as far as bringing it to court.
Correct.
Okay, but also, you brought it to court, but also indicates that the court doesn't have to give recognition automatically for that. I think we both agreed with that as well, correct?
Yes, Your Honor.
Okay. So there's comedy. The court has discretion, as we both agreed, whether or not they're going to domesticate this particular judgment. Right? Now, and again, I believe that Article 53 applies to foreign money judgments, as we did. Uncle Chunk said tribal judgment is a foreign money judgment, right?
Right.
Okay. So a party seeking recognition of foreign country judgment has the burden of establishing that CPLR Article 53 applies to that foreign money judgment, and that's 5203C. Therefore, the nation in this instance, the petitioner, bears the burden of establishing that the judgment, 1, grants or denies recovery of a sum of money. I don't think there's any dispute here, correct?
Correct.
And secondly, that under the law of the foreign country, where rendered, it's final, conclusive, and enforceable. Now, I don't believe there was an appeal here, correct?
No.
So it arguably is final in that regard.
Yes, Your Honor.
Okay.
The respondent did not appear in the action initially, did not appear at all.
Correct. And I'm aware of that. So, if we're in agreement here that those two things apply, and arguably that the nation did have a final, conclusive, enforceable judgment, but in addition, Article 53 goes on to say that it does not apply to a foreign country judgment, even if the judgment grants or denies recovery of a sum of money, to the extent that the judgment is a fine or a penalty.
Yes, Your Honor.
Now, if you look at the order and judgment of Cayuga Nation Judge Joseph Fahey, in those papers, the order and the judgment, it's referred to as a fine at least 3 times. It's either a civil fine or a monetary fine. So it's a fine. Can we agree with that?
Yes, Your Honor.
And I think the basis of that institution of a fine was for contempt, correct?
It was for contempt and also the violation of the business ordinance, which imposes a penalty of $1,000 per day.
Which was arguably the act of contempt that the court found below.
Correct.
Let's talk about jurisdiction first and foremost. And I think maybe Judge Porsche was referring to this in his decision. When you look at Comedy 2, also, you're looking at jurisdiction, correct? Whether or not the court had authority or power to bring on this action. And I'm really pretty familiar with the record, and I didn't see anything in the record regarding proof or personal jurisdiction over Mr. Seneca Carl. And in this sense, I don't see an affidavit of service that was presented to this court as far as that's concerned. And when I speak of that, I think you're probably familiar with the administrative order of the chief administrative judge of the court signed by Lawrence Marcus back on March 12, 2018 in reference to 20271, correct?
Yes, sir.
And it's a non-mandatory model, correct?
Correct.
And refers to, at least on the petition itself, I believe it's paragraphs 6 and 7. It speaks that when presenting this to the court, the Supreme Court in this instance, that the tribal court had personal jurisdiction over the parties. And that none of that was presented to the court, correct?
No, well, I'm sorry, Your Honor. When we brought the proceeding and the respondent in the proceeding did not appear. Okay.
I'm speaking, right. But
Right.
there is no evidence in your paperwork presenting this for recognition under 20271 that there was an affidavit that Mr. Seneca Carlin was served.
Correct.
So there's no evidence. It's non-mandatory, but if the court, Judge Porsche in this instance, wants to look at this particular judgment, he wants to make sure that Mr. Seneca Carlin was properly served, and that wasn't presented before him, correct?
Correct.
And also says that the tribal court judicial system provided due process. That's paragraph 7. And again, these are not mandatory requirements, but again, that you would think that the court had this information available to them when they considered it. So we both agreed that to the extent that it's a fine or a penalty, it's not enforceable under 5302. Can I ask you a question then? I will ask you a question then. In reference to the orders themselves, in this instance, the fines that were implemented, when you refer to the judgment or orders of the Nation Tribal Court, they referred to Section 4.5, correct?
Correct.
And they based upon instituting a judgment in the amount of $28,000 based upon that particular paragraph, 4.5, and the judge did refer to that.
Yes.
And if I look at 4.5, this is from the nation's own judiciary law, correct?
Yes.
And the nation so prepared this, and it was approved by the tribal council.
Yes, Your Honor.
Correct. It says any person found in contempt of court may be fined in an amount not to exceed $1,000 per act of contempt, and not to exceed $5,000 per instance of continuing contempt. And in instances of continuing contempt, each day shall constitute a separate act of contempt. So now the nation's law appears to set forth a maximum fine of $5,000. Seneca John was fined $28,000. So if Seneca John had paid this within 3 days, his fine would have been $3,000. Is that right?
Yes, Your Honor.
But if paid after 10 days, wouldn't his fine only be $5,000? Because it says it shall not exceed $5,000.
I understand the court's question, Your Honor. However, the specific language of the business ordinance says $1,000 per day.
I'm looking at what Judge Fahey utilized to institute this. His reference in his own judgment order is the section 4.5.
Yes, it does.
And I'm going to fine you $28,000 based upon your noncompliance. And that's a legislation from the nation itself. We
Yes.
agree. So arguably, a court could hold that against the nation because they're the ones who drafted it. So, by bringing this proceeding and asking the court below, Judge Torsch in this instance, to fine Mr. Seneca Carlin a sum of $28,000 based upon the nation's own law, which says it cannot exceed $5,000, aren't you then asking the state Supreme Court to apply a particular fine in an excessive amount according to their own legislation? You're asking New York State to domesticate that, take that on. And as we both agreed beforehand, a fine or a penalty is not enforceable here in New York State. So you're asking New York State to apply the tribal law here when New York State law indicates it's not applicable to a fine or a penalty. Is that right?
Yes, Your Honor.
And it's an argument that some may indicate is not preserved in this instance, but I want to bring it to your attention. Maybe in the interest of justice or judicial notice or something along those lines, the court could examine and give recognition to something along these lines. And this is another one of the nation's specific laws, and that concerns the qualifications of the judges. Okay. And you're aware of it. You know what I'm going to ask. You know what I'm going to say.
Yes, of course.
It's been said, I don't know how many times in the briefs. Talks about qualifications and it talks about eligibility, correct?
Correct.
And the initial judiciary law under section 1.11-1 reflects that in order to be eligible for appointment, and in this instance there's no argument that Judge Fahey was not elected, he was appointed, correct? So
Yes, Your Honor.
for appointment, that they be an enrolled member of the nation. And additionally, the candidate shall hold at least one of the specified degrees, whether it's a Juris Doctor or Master's degree or something along those lines.
Yes, Your Honor.
Right. So, arguably, Justice Fahey is not eligible to sit in this court because he's not an enrolled member at the time of the decision to fine Mr. Seneca Carl $28,000.
The issue I would have with, I'm sorry, Judge.
I said Seneca Carlin and Seneca John, I apologize.
May I continue?
Yes, please, thank you.
The issue I would have with that is that the issue of Judge Fahey's qualifications was taken appropriately to the nation's highest court, the Nation Court of Appeals, presided over by Judge Carney. Judge Carney rendered a very detailed decision regarding this and said he was properly appointed. That decision is binding on other courts.
He said he was qualified. He never said he was eligible.
I understand.
And if I extend this argument as well, I could probably extend this to Judge Carney as well. He is not an enrolled member of the Cayuga Nation either, right?
No, he's not, Your Honor.
And I don't want to say that this has come up, and it's been argued before, maybe it was a drafting concern of the nation because it's being brought up. It's been addressed. Why? Judge Fahey's not an enrolled member. It says enrolled member. It's clear. It's unambiguous.
Right.
It was changed.
Correct.
It was October of 2022, I believe, right?
Yes, Your Honor.
And you attached a copy of the amended judiciary law
Correct.
to the motions opposing or support of your motion to re-argue or renew, correct?
Yes.
Yeah, and you also attached Judge Carney's memorandum decision.
Yes, Your Honor.
Right, okay. So arguably, 11.1 is before the court.
Are you asking me the question? Your Honor?
I would maintain this.
Okay, yeah. Yes, Your Honor.
I've asked you a lot of questions,
Yeah, Your Honor.
and I've probably cut into some of your time.
No, that's fine.
I want-
Your Honor, the point I would make is that none of these issues that the court has raised were raised in Judge Porsche's decision. Okay? Judge Porsche had an issue with the appearance of the judgment. He said it was not overtly endorsed, stamped, and attested to.
Right,
That's-
he indicated that when I receive a judgment from a foreign judgment, I usually receive these. It's not here.
Correct. And we cured that in the second case, the case I'm arguing next, by attaching an affidavit from the Nation Court clerk certifying the judgment.
But I know we did. We talked about comedy. We talked about, the discretion. It's a fine or a penalty. Again, you're asking New York State to apply a judgment which New York State would not do in the first place. Correct?
Yes, Your Honor.
So that's for the court to consider.
Yeah. Yeah. The only other thing I would add, Your Honor, is that, does Your Honor have still a question about personal jurisdiction under the Letchison case?
No, I mean, I think Judge Porsche appeared to qualify his initial decision wherein he commented that, well, it's not jurisdiction before this court, which you're correct, it's jurisdiction before the tribal court.
Right.
And I think we both indicated that information that was presented to him at that particular time, there was no affidavit of service that Mr. Seneca John was served properly.
There is an affidavit of service of the notice of petition.
Correct,
Yes.
correct there is, but there's not. I'm looking at jurisdiction
Sure.
in the tribal nation court.
Yes, Your Honor.
Right, that's where I think that the jurisdiction has to apply.
Correct. The issue I would raise, Your Honor, is that none of these arguments the court has brought up were raised below. So they're not even preserved for appeal.
The court has the ability, again, you're asking this court, at minimum, to enforce a fine or a penalty, which this court, the state court, could not do in any instance. And we both agreed that Article 53, foreign judgments, enforcement of foreign judgments. And that's what you're trying to do. We talked about it right in the beginning. You're trying to enforce a foreign judgment from the tribe.
I understand, Judge, but 202.71 does not explicitly say that it incorporates Article 53.
Article 53, if you're familiar with the legislative history
Yes,
of, are you? Okay. The legislative history originally had 53 in there, correct?
Yes, correct.
It did.
That was a draft version of it.
That was a draft. I understand it.
Right?
It did. I'm not saying it does now, because it doesn't. It says comedy.
Correct.
And what's comedy? Comedy could be public policy,
Could be.
all right? Comedy could be, and public policy is if there's no jurisdiction, why should this court enforce something where there's no jurisdiction below? Public policy.
Understood.
Due process as well, and whether or not a person was properly served at the lower level. Those are all considerations for the court. Those are all considerations under 20271, which applies. So this court has the ability to examine 20271 and determine that, yes, you did file those 3 documents, but again, we agreed by just filing those 3 documents doesn't automatically mean that that judgment is something that will be domesticated or recognized by the state Supreme Court justice.
Understood. But we are not pursuing this under Article 53. We are pursuing
It doesn't, I don't think it matters. Article 53, let's go back to Mr. McConnell. Tribal money judgments may receive recognition pursuant to Article 53 of the CPLR.
I understand, Judge.
Anything else?
Well, I'd just like to say that 202.71 was not intended to frustrate Indian nations in taking judgments and domesticating them in New York State.
Exactly. It was to enhance it, correct?
Yes.
Because before 20271, and you look at the legislative history, before that, Native litigants were required to relitigate in state Supreme Court.
Right.
Correct.
Yes.
Which was improper. I could use a stronger word, but I won't. So, 53 was always available. What was not available before 20271 was the ability to bring an action for enforcement of a tribal judgment in relationship to an estate, or a contract case where it was litigated below and there was some sort of, afterwards there was a judgment that was informed. And that's what was something that could have been done, rather than re-litigating this again. They weren't enforced it because it was an injustice to the Native nations to have to do that, the litigants there. It was improper. It really was. And apparently it took a long time for 20271 to be passed. So they already had 53. And as McConnell says, 53, it's going to be utilized to enforce these money judgments. So 53 is always available.
Understood.
But not for fines,
Yeah, I'm sorry, Your Honor.
not for fines or penalties.
Yes. Oh, understood. Article 53 clearly says you can't enforce a fine or penalty.
Do you have anything further?
Nothing, I have nothing, Your Honor.
Mr. Alcott,
I'll have additional arguments in the second case.
Thank you.
Well,
No.
oh, you mean the
You wanna
second
segue
set?
that?
No, the
No,
second
no,
set.
no, let's
Okay.
take this. Mr. Alcott, thank you.
Thank you.
You can proceed.
May it please the court. I'm Joe Heath. I appear here for the respondent, Carlin Seneca. And I want to agree with much of the dialogue that's just gone on and just quickly repeat some of those, and also to address the preservation issues. Because the central legal question presented in both of these appeals, we have a second one coming up, as the court knows, as to re-argument. But the central legal question in both appeals from the same case from Seneca Supreme Court is, should this default tribal court money judgment have been recognized under New York law? That question is answered by New York law and the application of the CPLR. 20271 is merely a procedural bridge that assists Indian nations to bring their indigenous tribal court judgments into this court. It is not a substantive guideline. It's merely procedural. And whether or not a foreign court money judgment is recognized in New York is governed by Article 53. And clearly, there are many provisions, as we've heard before, of Article 53 that prohibited the lower court from recognizing this particular foreign court money judgment.
Counsel, can I interrupt you for 1 second? I understand, and we're going to hear a lot of what we have already heard, but I think that the basic argument I heard from counsel was that this matter might turn on the question of preservation. Okay, so I'd like you to talk to about that if you could. That issue being that a lot of these issues were not raised below, and why should the court exercise its interest in justice jurisdiction to reach these questions? I think that's what we'd like to hear about.
Thank you. There's several legal principles which authorize raising matters for the first time on appeal. Respondents may raise any legal argument in support of affirmance for the first time on appeal. This has long been recognized in New York for at least 40 years. There's a 1983 Court of Appeals decision, SEGA, S-E-G-A versus State, 60 New York 2nd 183, where the court ruled that this court finds nothing objectionable in the appellate division's action. On appeal, a respondent may proffer in support of affirmance any legal argument that may be resolved on the record. There are no new factual arguments in this appeal. They're all legal arguments specifically addressed to whether or not the statute, the governing statute, Article 53, applies. We're a respondent. We have raised legal arguments.
Counsel,
And-
let me ask you this. Okay, why is it important that we reach your issues in the interest of justice?
Because this court should not be recognizing a decision that violates New York law. Article 53 tells us when a foreign court money judgment can be recognized. Article 53 precludes it. Therefore, this court should not reverse that decision. However, inartfully, some of the supporting statements by the lower court are, this judgment should not be recognized in a New York court. That's pure interest of justice. It would certainly be unjust if this court said, oh, well, there wasn't enough litigation in the court below, and so we're going to ignore the rulings of our civil procedure law. I don't think that's the interest of justice. And the other thing I would point out is that when an appellate division exercises its interest of justice jurisdiction, that is not reviewable by the Court of Appeals. Either the fact that you exercised it.
We're very well aware of that.
Okay. So that is why it's preserved. There are legal arguments based upon the record from the lower court, and those legal arguments are very clear that this court should not help recognize this judgment.
Thank you.
Mr. Heath, good morning.
Good morning.
I know you're familiar with the Cayuga Nation. You're familiar with the Cayuga Nation, correct?
All two, Judge.
Prior to let's just say, there's still a traditional form of government in place. Would you agree with me?
The current government bringing this case is not a traditional
I
government.
understand it, but there's still a traditional form. There's still chiefs.
There definitely is a council of chiefs, yes.
Right. And that's a traditional form of governance.
Correct.
Clan mothers, correct?
Chosen by clan mothers with removal authority in clan mothers. Very much like, as the court knows, I'm general counsel for the Onondaga Nation. Very much like that.
And none of these chiefs have been dehorned.
I'm sorry, I didn't hear
They
that.
haven't been dehorned, correct?
No.
So there's faith keepers as well. Correct? There's
Say
faith
again?
keepers?
I'm sorry, the system
All right,
is...
that's my problem. There's faith keepers as well, correct?
Absolutely.
All right. So those chiefs, clan mothers are recognized by the Haudenosaunee Confederacy, is that correct?
Correct. There's a Grand Council of the Confederacy that still meets at Onondaga.
Right. And the Cayuga Nation participates in the Grand Council.
The Condole chiefs
Correct.
come there.
And it's been referred, the Grand Council's been referred to as the world's oldest representative democracy.
That's correct. It's over 1,000 years old. It's recognized by an act of Congress in the 1980s as the foundation of the United States Constitution.
So this is something that's not been brought up below, and I'm sure Mr. Elcott will bring that up. But by domesticating the judgment brought by the nation court, isn't the state court, or ultimately this court as well, if we reverse and recognize that judgment, if this court was to recognize this judgment, wouldn't the state court or this court be recognizing or choosing one government over another?
Absolutely, Judge, and that is forbidden by the Court of Appeals in the Campbell
The Campbell
decision,
case,
as the
correct.
court well knows.
Right. Campbell Court said that the tribal courts, the state courts, New York State courts should not be embroiled in a leadership dispute, correct?
That's correct.
Anything else?
No. Any questions from the court?
Thank you.
Thank you very much.
I'm going to, wait,
Yeah, there.
I guess I thought we were going to argue all at the same
I
time.
guess not, no.
Okay, go ahead.
May it please the court, once again, Lee Alcott.
And this is the Cayuga Nation versus Dustin Parker, correct?
I thought we were calling
That's what I was
2300-7.0.
trying- I know, that's
All
what I
right,
was
I'm
trying.
sorry, okay,
That's
all
what
right.
I was trying to say
All right,
earlier.
all
I
right.
wanted you to
I
argue both
apologize.
of them at the same time.
All right. Here, special term abused its discretion. Respondents again did not appear. We gave the court exactly what it was looking for when it said, I don't like the look of the judgment.
We understand that. but
Okay.
We still have the same issues that we went through
All right.
previously.
All right.
The case before that.
Well, there are several statements that the court made that we think warrant this court's attention. First, the court made a statement that the nation does not have a reservation. We all know that the nation has a 64,015-acre reservation. Second,
That's the historical
correct?
reservation from the 1794 Treaty of Canandaigua.
That is correct, Your Honor.
Okay.
Okay. It then went on to question.
Hasn't that been challenged in the Court of Appeals?
No. No, that has not been challenged and found to be disestablished. And
No, it hasn't been disestablished.
Correct.
But didn't the Cayuga Nation versus Parker,
Cayuga Nation versus Gould, first of all,
I'm looking at Parker as well.
okay?
Because that was after the Sherrill case.
Yes,
Didn't the Court of Appeals adopt the Sherrill decision wherein basically indicating that, excuse me for a second, indicating that they denied their claims based upon the theory of laches.
correct. But the issue there, Your Honor, is distinct from the issue here. The Sherrill case established that a nation could not regain title once title passed and render those properties sovereign. We had to go through a trust process, which the nation is doing now. But it did not say that the Cayuga Nation's reservation has been disestablished or doesn't exist.
It hasn't, just like McGurk.
Correct. Well, that's the most recent case.
Right.
But the Court of Appeals also said, in Cayuga Nation versus Gould, that every federal and state court that has examined the question as to whether the nation's reservation was disestablished has answered that question in the negative.
Okay.
So the reservation clearly exists. It also took pains to question Judge Fahey's authority. We submit that Judge Fahey's appointment as a Cayuga Nation court judge, as a respected former county court judge, was entirely proper, and the nation has the ability to do that. Finally,
They
it
do have
took,
the ability to do it, but their own law says they can't. He's not eligible for appointment. We had that discussion
Yes.
5 minutes ago.
I understand, Your Honor, but
We
we
don't have
also,
to go over the same
Okay,
arguments.
all right.
If you have something specific to this argument.
okay. These statements by the court below were all gratuitous. They were all dicta. He wasn't required, special term was not required to rule on the existence of the nation reservation. Special term was not required to rule on any of these
We
issues.
understand
Okay. The only thing I would add, Your Honor, is that, because I think Judge Bannister was teasing this out a bit, it remains our contention that 202.71 operates independently of Article 53.
You've made that clear.
Right, thank you.
Thank you. Do you have anything to add on this discussion?
Very briefly, because the original refusal to recognize was proper, that's the basis to deny the motion for re-argument. If you grant the motion to re-argument, you then recognize an improper judgment. It's very simple. There's some dicta in these decisions that is not helpful.
It's not relevant.
It's harmless error. The fundamental decision in both of these appeals was that this judgment should not be recognized under Article 53 of the CPLR.
Thank you.
Thank you.
Now, 268, 269, well, it's 268 here. Pardon?
No, it's 268, 269, right? Because the other ones are different. Because you have a different parties appealing.
Yeah, I'm sorry.
So 268, 269 is probably arguable now.
I'm not listening to you anymore. 268, 269.
You're probably do you well.
I'm sorry, Your Honor, is this CA 2201-776? That's the
Yes,
CA.
that's 268.
Okay.
Cayuga Nation versus Dustin Parker.
And you're going to argue, though, right, 268 and 269 at
Yes.
the same time?
Yes. Okay.
Maybe we need to get this straight so that you can get
My
it
fault.
straight.
I made a chart,
I don't sit,
and it even applies to when I have to switch seats. So I'm very much in tune with where I have to be, so try not to throw me off, okay? Again, we have a ruling by special term that it did not like the appearance of the judgment, okay? That ruling was in error. 202.71, I'll say it again, only requires an Article 4 proceeding to be commenced by notice of petition and attaching the judgment. That's exactly what we did. The request that the court take judicial notice of the original Cayuga Nation judiciary law pursuant to CPLR 4511 requires notice, which must be given, and respondents concede they did not raise that issue below. In fact, all of these arguments...
well, didn't you bring it into play at minimum by referring to Judge Carney's decision?
Yes, Your Honor, but that is in the record.
What's that?
In one of the cases, that the statement from Judge Carney regarding the appointment of Judge Fahey is in the record.
He refers to, right, he refers to 11.1 concerning the appointment of an ineligible judge.
Yes.
Again, he refers to Judge Fahey as qualified, but
Right.
not eligible. And you need to have both. If you look at the nation law, you have to be qualified first. You have to have a Juris Doctorate degree, you have to be a master's, you have to, one of those list of other
Yes.
10 other items. And he's referring to that
Yes, Your Honor.
in his decision.
Correct.
And then again, you have to be an eligible member.
I understand the court's question, Your Honor. What I would simply submit is that getting into the issue of eligibility of judges, okay, treads heavily on the nation's sovereignty. And I know all members of this court are familiar with that issue.
Correct. And then you change it to take that out.
Correct.
But you're still asking the court to enforce a fine or a penalty.
Yes, Your Honor. But again, we don't think Article 53 applies, so that's what we have a disagreement about.
We do. Thank you.
The order should be reversed.
Thank you.
Appreciate your time. Thank you, sir.
Brief enough.
Good afternoon, Your Honors. Eric Gergen from Nixon Peabody on behalf of Dustin Parker and his businesses. I represent him in all 4 appeals before this court. I'll address the first 2, even though they're all related, as you might guess, and are
Very
brief-
similar. you know.
Very similar.
Very similar briefs, very similar judgments, very similar orders.
That's
No,
correct.
Hold them up to the light and they mirror each other.
That's correct, Your Honor. And I will not belabor all the points that have just been discussed, except to add that the entire discussion that the court had with counsel in the prior case applies with equal force here. All of the judgments at issue in both the Seneca County cases, which are these two appeals, and then the two appeals following emanate out of Cayuga County, in which Mr. Parker lost and the judgments were domesticated, all involve a fine.
So 53 does apply, as you're saying.
That's correct. And that was not a central point of Mr. Parker's briefs before this court, but nonetheless, Justice Montour's concerns with respect to the Cayuga Nation judgments at issue all expressly say on the record that it was a fine, and all of them exceed the $5,000 maximum allowable fine.
Go ahead.
Do you have a position on preservation?
Same arguments that Mr. Heath made, Your Honor. They, as we conceded, and we were upfront and open with the court, these issues were not preserved. And the main reason is that several of these judgments were entered upon default before Mr. Parker even knew about it and before he retained my law firm. So Mr. Parker was already behind the 8 ball and frankly didn't have much of a shot here. And so we made the arguments that we could, and then once we examined the statute in question, it revealed that, as Your Honor pointed out, and as our briefs explain, the judge at the tribal court level and the appellate judge was not eligible under the Cayuga Nation's own law.
And that would be your argument with regard to the interest of justice jurisdiction that you're asking us to apply to this case?
Yes, Your Honor. And also, too, we also mentioned that various versions, each of the records in this case are different, but the court...
Not much.
Not much, but the court could take judicial notice of the original Cayuga Nation judiciary law and the amended one. I believe the amended one was made part of the record in the Seneca County appeal case, but importantly, the operative version and the amended version were filed in post-judgment proceedings in the Cayuga Nation cases. So that is part of the record of this very case, and CPLR 4511 allows this court to take judicial notice of foreign law.
Thank you. Now he again is going to switch places. You could have packed this stuff up before this to switch places.
I wasn't anticipating it was going to be that short, so.
Eric Gergen again, on behalf of the appellant, Dustin Parker, and his businesses in the two related cases that emanate out of Cayuga County, in which Mr. Parker lost and the judgments were domesticated by Supreme Court. The same arguments apply, but importantly, all of the judgments, like as the brief in all the cases argued, were entered before the October 2022 amendment to the judiciary law. As such, the original law is applicable to these proceedings, and again, Mr. Parker renews his argument with respect to the fines, that they're prohibited, enforcement's prohibited under Article 53, and that the judgments at issue in these cases also involve fines.
Let me ask you a question. Now, these two cases, do they both involve the Montezuma property?
Yes.
Because they're in Cayuga County, right?
That's
Right,
correct.
that's why we're in front of, they pick in front of Judge Leone? Okay.
Yes, Your Honor.
If you're looking at the two judgments and orders, there's notice of violation was made on 2/17/22 under both.
That's
There are
correct.
two orders. One was signed, well, I'm sorry, they're both signed on the same day by Judge Fahey on March 11th, 2022. The one judgment under our court number 270 was for $126,000, correct?
That's correct. Your
And these both of these two cases involve the violation, reported violation of Mr. Parker of the business ordinance law requiring a license.
That's correct.
All right, so it's $126,000 under 270. The second judgment taken earlier on March 21st was for $39,050. Is the 39 part of the 126? Does anyone know? I mean, there's the same notice of violations, same orders, or the orders were signed the same day. Maybe I'm just confused. Doesn't take a lot. You know, but
Your Honor, my understanding is that...
Maybe this isn't relevant.
They don't overlap,
Okay.
that they're two separate judgments, but the underlying violation that the second judgment was predicated upon occurred from the first judgment. So it's all related.
All right, I didn't know whether or not the 39 should be included in the 126, though.
My understanding is
was
it's
first and foremost.
separate,
Okay.
yes.
All right, I'm sorry, go ahead.
However, if we were to apply the $5,000 limit that Justice Montour raised previously,
Yes.
it would apply to just one and not the other, because the other would sort of be part of the same series of events, correct?
That's correct, Your Honor. Yes, it all emanates from the same violation, which resulted in the imposition of a fine, which CPL Article 53 doesn't allow enforcement of. So it's all,
Otherwise, you could bring the same application every 5 days and get around the $5,000 cap. That's within the ordinance.
that's exactly
Don't give any
right.
ideas, okay?
That's exactly. Unless the court has any additional questions, we rest on our brief. Thank you.
Thank you.
May it please the court, Lee Alcott again, on behalf of the nation. Your Honors, this issue of preservation, I think, needs to be taken very seriously. Otherwise, it's going to stand appellate procedure on its head. Cases are uniform, that if it's not preserved, it cannot be raised on appeal. If we start to go beyond that, we're going to have all sorts of problems. You either preserve it or you don't preserve it. None of these defenses, whatever you want to call it, were preserved at all. And with regard to this particular case, we contend Judge Leone got it right, just as Judge Odorizzi did in a dozen cases. The cases ruled on by Judge Porsche, where he denied relief, we contend are aberrations. Judge Odorizzi, we listed the cases in our brief, got it right. With regard to the qualifications of the judge, as counsel has raised, we contend that Judge Carney's decision, once he determines that Judge Fahey is qualified, the question of eligibility has already been passed. Eligibility would seem to be a predicate
It
for qualification.
references eligibility. The qualifications paragraph references eligibility.
Yes.
Right, so if you're qualified, sure, but you still have to become eligible.
I'm sorry, Your Honor, I respectfully disagree.
I know, we disagree, that's fine,
Yeah.
but that,
I think
That's my reading.
when Judge Carney, the judge of the nation's highest court, made the determination that Judge Joseph Fahey was qualified, he didn't even get into eligible. Once you're qualified, that's it. You don't go backwards and look at whether he was eligible.
but it says that. You said you have to be eligible. The qualifications paragraph looks back to the eligibility paragraph.
I understand, Your Honor.
So
Judge-
that tells me that you have to be eligible as well.
Judge Fahey, I'm sorry, Judge
We
Carney.
disagree.
Yes.
Right.
Judge Carney's decision was well-reasoned. He noted the fact that, as we pointed out in our brief, initially, we could not find a nation member who was qualified to serve as a judge. So we went outside of the nation and looked to respected jurists to be appointed to our court. We have Judge Fahey. and
We did
have
that
Judge
beforehand.
Carney. Yes,
Right.
yes, we had to. The way the statute was initially written, we'd have to find a nation member. We could
The
not
way
find
your,
a
the way
nation
your
member.
law is written, you have to be eligible.
Yes, and Judge Carney says, it's worth noting that we tried to find someone who was qualified within the nation. We could not find someone. We had to go outside and
I mean,
appoint.
eligible.
Eligible, well, again, eligible, qualified. If Judge Carney had said, well, sorry, he was qualified, but he wasn't eligible, then we'd be having a different argument here. But once he says he's qualified, that seals the deal as far as we're concerned.
Thank you.
Thank you, everyone.
Thank you.
Stand at recess, 2:58.